This is the brief on crimes against public interest in Philippine law. We're breaking down the serious offenses that completely undermine public trust, from forging documents to manipulating the economy, showing you exactly why the law treats deception as a direct threat to a functioning society. First, forgery and falsification. It's not just printing fake money. It covers counterfeiting government seals and documents too. Think of it like slipping a brittle, counterfeit gear into a massive machine. It's not the fake gear itself, it's how it destroys our trust that the machine's actually going to work. Crucially, you don't even have to make the fake item. Just possessing counterfeit cash or forged documents with the intent to use them is absolutely a punishable crime. Second, false representation and testimony. The law scales up from faking physical objects to faking identities and the truth itself. It punishes usurping authority, basically pretending you're a public official, and perjury. So what crosses the line into perjury? Well, it's not just an everyday lie. You literally have to deliberately lie about a material matter crucial to the case, right under oath. Interestingly, acting in good faith is a totally valid defense. Finally, commercial frauds and price manipulation. We're moving from individuals faking documents to cartels manipulating entire markets. The Price Act strictly penalizes hoarding, profiteering, and cartels. To put that into perspective, if a business holds 50% more basic goods than their usual inventory, the law considers that prima facie, or at first sight, evidence of illegal hoarding. Ultimately, whether it's a forged signature, a false oath, or a rigged price, Philippine law aggressively targets any deception that fractures society's foundational trust.
Picture two acts of forgery. On the left, someone stamps a counterfeit movie theater ticket. On the right, someone laminates a fake driver's license. In both scenarios, the forgery is caught the second it is handed over. No one loses a single peso. Zero financial loss occurs. Yet the legal outcomes are completely at odds. The forger of the theater ticket walks free. The forger of the driver's license has committed a felony and faces years in prison. When law students and practitioners first encounter this, they instinctually look for the financial victim. They evaluate these acts through the lens of property crimes, like theft, assuming a crime requires monetary damage. But under Title IV of the Revised Penal Code, the criminality of a lie is not determined by the money lost. It is determined entirely by the medium in which the lie is told. Title IV treats the integrity of state instruments as the primary interest, penalizing the act of lying regardless of financial status. Public faith is the foundational trust citizens must have in the instruments of the state to function as a society. Without it, the system collapses. Title IV protects this trust sequentially. It begins by penalizing an attacks on the highest symbols of the state, the Great Seal and the national currency. From there, the law descends into the everyday infrastructure of this trust, the falsification of documents, governed by Articles 171 and 172. The legal architecture is highly modular. Penalties shift based on the actor, the specific method they used, and the medium they altered. To solve any falsification problem, you have to stop asking who was harmed and start asking what was altered. The Revised Penal Code categorizes all documents into three distinct tiers of importance. We can map this out using a three-column matrix. First, public or official documents. Second, commercial documents. And third, private documents. Column 1 covers public and official documents. These require the intervention of a public officer, or are executed in response to the exigencies of public service. Jurisprudence gives us clear examples, like an official cash book keeping track of public funds, or a burial permit. Column 2 contains commercial documents. These are the papers, instruments, or notes used to facilitate trade or credit transactions in the course of business. This includes bank checks, warehouse receipts, known as quedons, and airway bills. Finally, Column 3 is for private documents. These are agreements executed strictly between private persons, with absolutely no intervention by a notary public or authorized official. An unnotarized deed of sale falls here, as does the movie theater ticket from our earlier example. The moment a document is categorized into one of these three columns, its specific standard of truth, and the legal penalty for altering it, is permanently locked in. Let's isolate the first two columns, public and commercial documents, governed by Article 172, Paragraph 1. The absolute rule for these columns is straightforward. Damage, or even the intent to cause damage, is completely immaterial to the crime. The Supreme Court anchored this rule in the case of Dava versus People. In Dava, the court established that the falsification of a driver's license, a public document, is a consummated crime the exact moment it is made. It does not matter if the license was ever used to deceive a police officer or cause actual harm. To understand the reasoning behind Dava, we look to the ruling in Demagus versus Mullane. The Demagus ruling identifies the injury as the destruction of truth solemnly proclaimed in the document. The loss of veracity is the crime.
For public and commercial documents, the integrity of the document itself is the victim. Altering it is a direct attack on the state's reliability. Now we shift focus entirely to the third column, private documents, which are governed by Article 172, Paragraph 2. Here, the rule flips. For private documents, actual damage or the intent to cause damage to a third person is absolutely essential. Because private documents do not carry the state's guarantee of truth, the state's interest in policing them is much lower. This creates a strict timeline for criminal liability. First, there is the falsification of the private document. Then, there must be an independent act utilizing that document. Finally, that act must result in damage or the intent to damage. The Supreme Court enforced this timeline in U.S. versus Parasayo. The court ruled that merely lying on a private paper is not enough to secure a conviction. There must be an independent, subsequent act that operates to damage a third person. In the private sphere, a lie is only a crime if it is successfully weaponized against another person's interests. This brings us to the complex crime, the exact point where crimes against public interest collide with crimes against property. This raises a critical question. When does falsifying a document to steal money become one singular complex crime, and when are the acts treated separately? We can visualize this using a simple Venn diagram showing where falsification and the crime of estafa, or fraud, intersect. Let's trace pathway A, defined by People versus Assistio, a case involving forged police stickers used as road passes. If a public or commercial document is falsified as a necessary means to commit estafa, it successfully forms a complex crime. The acts merge into a single, heavier penalty. Now, let's look at pathway B, guided by the ruling in People versus Co. Bang, which dealt with concealing and misappropriation. There is a strict exception here. If an estafa is already completed and a private document is falsified merely to conceal it, there is no complex crime. This happens because the intent to damage element, which is strictly required for a private document to be considered falsified, was already consumed by the estafa itself. The damage was caused by the fraud, not the subsequent cover-up. Understanding the medium of the document is the only way to accurately predict if a fraudster faces a single penalty or a compounded complex penalty. We can consolidate all these rules into a single diagnostic tool to evaluate any falsification problem. This flowchart starts with one initial question. Is the document public or commercial, or is it private? If it is public or commercial, damage is immaterial, and if used to commit fraud, it complexes with estafa. If it is private, damage is strictly essential, and if it's used merely to conceal a completed fraud, it does not complex with estafa. This logic tree isolates the variables that dictate criminal liability, offering a systematic approach to legal classification. Let's return to the paradox of the movie theater ticket and the driver's license. To master crimes against public interest, practitioners must aggressively detach from the instinct to look for a financial victim. The Revised Penal Code evaluates truth-telling strictly through the lens of institutional trust. In public records and commercial trade, the law treats the document itself as the victim. Once the truth is altered, the crime is complete.
This video covers the syllabus for Criminal Law 2, focusing on crimes against public interest. We begin with Article 161 of the Revised Penal Code, counterfeiting the Great Seal of the Government of the Philippines and forging the signature or stamp of the Chief Executive. We will look at the penalty, the person liable, and the specific acts punished, including forging the Great Seal. The discussion continues with the acts punished under Article 161, specifically forging the signature of the Chief Executive. Forging means counterfeiting or imitating the genuine signature. We also cover forging the stamp of the chief executive. Next is Article 162, which addresses using a forged signature or a counterfeit seal or stamp. This article defines the penalty and the acts punished, which include knowingly making use of a counterfeit seal, a forged signature, or a counterfeit stamp of the chief executive. It also specifies the nature of the person liable. We continue with the elements of the crime under Article 162. These include: the counterfeiting or forgery was done by someone other than the offender knew about the counterfeiting or forgery, and the offender used the counterfeit seal or forged signature or stamp. If the offender is also the forger, Article 161 applies instead. Moving to Section 2, Counterfeiting Coins, we discuss Article 163 as amended. This covers making, importing, and uttering false coins. We examine the penalties and the persons liable. A counterfeited coin can be Philippine coinage or the currency of a foreign country, though the Spanish text uses the term moneda or coin. Under Article 163, we examine the elements of the crime, starting with false or counterfeited coins. This includes a definition of a coin, and notes that even former coins withdrawn from circulation can be counterfeited. The focus is not only on the harm to the public if the coin returns to circulation, but also the possibility of the counterfeiter continuing their trade. Another element of the crime under Article 163 is that the offender either made, imported, or uttered such coins. We define import and utter. Notably, in the case of uttering false or counterfeited coins, the offender must have connived with the counterfeiters or importers. Next, we cover Article 164, concerning the mutilation of coins and the importation and utterance of mutilated coins. We discuss the penalties and the two crimes defined: mutilating coins of legal Philippine currency with intent to defraud, and importing or uttering mutilated coins in connivance with others. Article 165 covers the selling of false or mutilated coins without connivance. The penalty is 1 degree lower than those under Articles 163 and 164. The two acts punished are possession of a counterfeit or mutilated coin made by another, knowing it is false or mutilated, and intent to utter. The second act punished under Article 165 is the actual uttering of false or mutilated coins, knowing them to be false or mutilated. The elements include the actual uttering and the knowledge of falsity or mutilation. Connivance with counterfeiters or importers is not required under this article. We now move to Section 3, Forging Treasury or Banknotes. Article 166 addresses forging treasury or banknotes, or other documents payable to the bearer, as well as importing and uttering such false or forged documents. The article details the penalties for counterfeiting obligations and securities of the Philippines, notes of authorized banks, foreign government documents, and notes of authorized foreign banks. Article 166 punishes 3 acts. The first is the forgery or falsification of treasury or banknotes or other documents payable to the bearer. This slide shows how forgery or falsification is committed, referencing related articles and court cases, including complex crimes like estafa through falsification. The second act punished under Article 166 involves notes, other obligations, and securities that may be forged or falsified. This includes treasury or banknotes, certificates, and other obligations or securities payable to bearer. Payable to bearer means negotiable by mere delivery, expressed to be payable to bearer, or payable to a fictitious person or bearer. The obligations or securities of the Philippines that can be forged or falsified under Article 166 include bonds, certificates of indebtedness, national banknotes, coupons, treasury notes, fractional notes, certificates of deposit, and bills. Continuing with Article 166, other documents payable to bearer include drafts for money and other representatives of value issued under any act of Congress. Note that Philippine national bank checks are considered commercial documents and are not covered by Article 166. This scene continues the discussion of Article 166 on forging treasury or banknotes. It covers importing false or forged obligations or notes, defining importation, and noting that the obligation or note must be forged or falsified in a foreign country. It also discusses uttering such false or forged obligations or notes in connivance with the forgers or importers, and the definition of uttering. Article 167 addresses counterfeiting, importing, and uttering instruments not payable to bearer. This includes instruments or documents of credit issued by a foreign government or bank. The offender must have either forged, imported, or uttered such an instrument. It also discusses the need for connivance in uttering, unless the utterer is the forger himself. Article 168 concerns the illegal possession and use of false treasury or banknotes and other instruments of credit. It specifies the persons liable and the penalty, which is 1 degree lower than those under Articles 166 and 167. The elements include: the document was forged or falsified by a person other than the offender, and the offender knows this fact. Proof of knowledge of forgery under Article 168 can be shown through the offender's conduct. Examples of such conduct include failing to explain possession of a forged bank bill, destroying a forged bill upon examination, or initially denying and then surrendering counterfeit bills when confronted by authorities. The third element of illegal possession and use of false instruments is that the offender performs specific acts. These acts include using the forged or falsified instrument or possessing it with the intent to use it. Possession of counterfeit US $20 bills, for example, is a violation of Article 168. Regarding illegal possession, the intent to use, coupled with possession, is sufficient to consummate the crime under Article 168. Conversely, mere possession without the intent to use is not a crime. However, the accused bears the burden of satisfactorily explaining innocent possession of forged bills. This section addresses an instance of an impossible crime related to illegal possession of false treasury notes. The issue arose because the notes were so poorly reproduced that they could not be accepted as genuine money. This case suggests a need for re-examination concerning whether forgery constitutes a crime against persons or property, which is an element of an impossible crime. We move on to Article 169, how forgery is committed. Forgery includes acts of falsification. The acts constituting forgery include giving the false document the appearance of a true and genuine document, and erasing, substituting, counterfeiting, or altering figures, letters, words, or signs. Article 170 covers the falsification of legislative documents, including the penalty and who is liable. The elements of this crime are a genuine legislative document, alteration by the offender without authority, and the alteration must change the meaning of the document. Falsification of a legislative document is limited to alterations that change its meaning. Other acts of falsification may fall under Articles 171 or 172 of the Revised Penal Code, depending on the offender. Article 171 addresses falsification committed by a public officer, employee, notary, or ecclesiastical minister. It details the penalty, the persons liable, and the elements, including that the offender is a public official or notary and takes advantage of their official position. If a private individual commits the act, Article 172 applies. A public officer who does not take advantage of their official position may be charged with falsification by a private person under Article 172. Falsification requires the offender to falsify a document. Documents under paragraphs 6, 7, and 8 of Article 171 presuppose a genuine document that is falsified by means of alteration or intercalation. The first 5 paragraphs of Article 171 relate to simulation or fabrication of documents and do not require a genuine document. Article 171 does not distinguish the kind of document falsified, as the intervention of a public officer makes the document public or official. Private documents in official custody are also covered. Falsification can be done by counterfeiting or imitating any handwriting, signature, or rubric. Counterfeiting requires an intent to imitate and a resemblance between the genuine and forged signatures. The resemblance must be sufficient enough to pass inspection in the rush of business. Absence of the requisites of counterfeiting does not necessarily negate falsification under Article 171, paragraph 2. Feigning refers to the forgery of something that does not exist. The article also punishes causing it to appear that persons participated in an act or proceeding when they did not, where imitation of a signature is not always necessary. We continue our discussion on falsification by public officer under Article 171. We examined the requisites for the offense, where an offender causes it to appear that a person or persons participated in an act or proceeding when they did not. Note that if the offender is a private individual, Article 172 applies instead. Article 171, paragraph 3 covers attributing to participants statements other than those they actually made. The requisites for this include: the persons participated in the act, They made statements, and the offender, in making the document, attributed false statements to them. Article 171, paragraph 4 addresses making untruthful statements in a narration of facts. The first requisite is that the offender makes statements in the document that are a narration of facts, distinguishing it from a conclusion of law. The second requisite is the offender's legal obligation to disclose the truth of the facts they narrated. Cases illustrate that this legal obligation is essential, such as an officer authorized by law to issue a certificate, but may not apply to cases like revealing a previous conviction on a personal data sheet. The third requisite for untruthful statements in a narration of facts is that the facts narrated must be absolutely false, not merely partly true or bearing some colorable truth. Also, the person making the narration must be aware of the falsity of the facts. The final requisite for untruthful narration of facts is that the perversion of the truth must be made with the wrongful intent of injuring a third person. However, wrongful intent is not essential when the document falsified is a public document. Article 171, paragraph 5, punishes altering true dates. The altered date must be essential. Examples of essential dates are dates of birth, marriage, and death. Altering a date to conceal a crime, even if the document's integrity is not affected, constitutes falsification. Article 171, paragraph 6, deals with making an alteration or intercalation in a genuine document that changes its meaning. The alteration must be on a genuine document, change its meaning, and make the document speak something false. Altering grades in examination papers is considered an act of falsification. Article 171, paragraph 7 covers issuing an authenticated form document purporting to be a true copy when no original exists, or including a statement contrary to the genuine original. Falsification under this paragraph can only be committed by taking advantage of an official position, though a private individual may be liable on the basis of conspiracy. Article 171, paragraph 8, concerns intercalating an instrument or note in a protocol, registry, or official book. Furthermore, if the offender is an ecclesiastical minister, the act must relate to a record or document whose falsification may affect the civil status of person. We now move to Article 172, falsification by private individual and use of falsified documents. This article specifies the penalty and 3 punishable acts. The first is falsification of a public, official, or commercial document by a private individual. The offender must be a private individual or a public officer who did not take advantage of their official position and committed any of the acts of falsification in Article 171. When the document is falsified, the possessor of a falsified document is presumed to be the author of the falsification, especially when they use, profit from, or take advantage of it. This presumption does not apply if the evidence of forgery is extremely doubtful. The act of falsification in Article 172, paragraph 1, must be committed in a public, official, or commercial document. A public document is one executed by a public official or in whose execution a public official intervened, like a driver's license or a receipt for collected taxes. An official document is issued by a public official in the exercise of their functions and is also a public document. A commercial document facilitates trade or credit transactions, such as bank checks or warehouse receipts. A mere blank form of an official document is not a document itself. A private document is one executed by a private person without the intervention of a notary or authorized person. In falsification of public or commercial documents under Article 172, paragraph 1, damage or intent to cause damage is not essential, but absence of malice is a defense in falsification of a public document. We begin with a discussion on falsification by a private individual and the use of falsified documents under Article 172 of the Revised Penal Code. This includes the falsification of a private document by any person. Falsification of a private document requires damage to a third person or intent to cause such damage. Mere falsification is not enough. An independent act to cause damage is needed. Also, the offender does not need to profit from the falsification. Next, we cover the elements of using a falsified document in a judicial proceeding, according to the last paragraph of Article 172. The offender must know the document was falsified by another and introduce it as evidence. Damage is not a necessary element in this crime. We also examine the elements of using a falsified document in other transactions. The user must know the document was falsified by another person, and the false document must be covered under Articles 171 or 172. Using a falsified document in a non-judicial proceeding must cause damage or be intended to cause damage to another person. This is distinct from use in a judicial proceeding, where damage is not required. Falsification may constitute a necessary means for committing other crimes, such as when the document falsified is a public, official, or commercial document. If a private document is involved, the crime might only be falsification of a private document or a different complex crime. Examples of complex crimes involving falsification include estafa through falsification of public document, theft through falsification of official document, and estafa through falsification of commercial document by reckless imprudence. We also discuss malversation through falsification of public document. Falsification through reckless imprudence applies when the document is public, official, or commercial and damage results. If the document is private and no damage occurs, there is no crime of falsification through reckless imprudence. Certain private documents can be considered public documents, such as a deed falsified before notarization. A private document also acquires a public character when it becomes part of an official record, certified by a duly authorized public officer. Falsification has no attempted or frustrated stage. The crime is deemed consummated, regardless of whether the offender achieves their objectives. A user of a falsified document may be considered the author of the falsification if the use is closely connected in time with the falsification and the user had the capacity to falsify it. Moving to Article 173, we cover the falsification of wireless, cable, telegraph, and telephone messages, and the use of said messages. The acts punishable include uttering fictitious messages, where the offender is an officer or employee of a relevant corporation or government agency. The second punishable act is falsifying a wireless, telegraph, or telephone message. The elements require the offender to be an officer or employee of the sending or receiving service, and the act of falsifying the message. The third punishable act is using such falsified message. The elements include the accused knowing the message was falsified by the person specified in paragraph 1 of Article 173, and the use of the dispatch resulting in prejudice or intent to cause prejudice to a third party. Next, we discuss false medical certificates, false certificates of merit or service under Article 174. Persons liable include physicians or surgeons issuing false medical certificates, and public officers issuing false certificates of merit, service, or good conduct. However, a certificate for large cattle does not fall under Article 174, paragraph 2, as it is unrelated to merit, service, or good conduct. Certificates of residence for voting purposes are considered certificates of similar circumstances. Private individuals who falsify certificates under Article 174 are also liable. We now discuss using false certificates under Article 175 of the Revised Penal Code. This crime has a defined penalty and requires elements like a physician or public officer issuing a false certificate, the offender knowing the certificate is false, and the offender using the false certificate. Note that the use of false certificates in judicial proceedings is covered under Article 175, not Article 172. Article 176 addresses the manufacturing and possession of instruments or implements for falsification. The acts punished include making or introducing instruments for counterfeiting or falsification into the Philippines. An example is manufacturing a seal in imitation of an official seal for making false certificates. The second punishable act is possessing, with intent to use, instruments for counterfeiting or falsification made or introduced by another person. The confiscated implements do not need to form a complete set, as long as they can be employed by themselves or with other implements. This article also punishes constructive possession. Moving to Article 177 on usurpation of authority or official functions. Representation of authority must be positive, express, and explicit. False representation can be shown by overt acts, such as when someone represents themselves as a police officer and performs related acts, like stopping buses. Article 177 is not restricted to private individuals. A public officer can also be guilty of usurpation of authority. Furthermore, the article as amended punishes the usurpation of authority or official functions of any officer of a foreign government. Usurpation of official functions involves performing acts pertaining to a person in authority or a public officer under the pretense of official position without being lawfully entitled to do so. This is distinct from Republic Act No. 10, which penalizes similar acts but is only applicable to members of seditious organizations. Article 178 covers using a fictitious name and concealing a true name. The elements for using a fictitious name include using a name other than one's real name and using it publicly. A fictitious name is defined as a name publicly applied without legal authority. Using a fictitious name in private transactions, such as opening a trust account under an alias, may not be considered public use, especially when privacy and secrecy are statutorily guaranteed, like in the case of bank deposits. The fictitious name must be used for specific purposes, such as concealing a crime, evading the execution of a judgment, or causing damage to public interest. Damage to public interest is distinguished from damage to private interest. Concealing a true name is distinguished from using a fictitious name. Publicity is decisive in the latter, but not necessary in the former. The elements for concealing a true name are the offender concealing their true name or personal circumstances, with the purpose of concealing their identity. Commonwealth Act No. 142 regulates the use of aliases, with exceptions for artistic and athletic purposes. However, the use of a substitute name generally requires authorization from a competent court, and only names properly recorded in the local civil registry may be used. Article 179 covers the illegal use of a uniform or insignia. The elements are using an insignia, uniform, or dress that pertains to an office not held by the offender or to a class of persons of which they are not a member, and using it publicly and improperly. The illegal use of foreign uniforms, decorations, or regalia is penalized under Republic Act No. 75, which requires the intent to deceive or mislead. Wearing the insignia or emblem of rank of the Armed Forces or Philippine National Police is penalized under Republic Act No. 493. Next, we examine false testimony against a defendant under Article 180. The penalties for this crime depend on the sentence of the defendant against whom the false testimony is given, ranging from death to acquittal. An additional fine may also be applicable. The elements of false testimony against a defendant include the existence of a criminal proceeding, the offender testifying falsely under oath against the defendant, the offender knowing the testimony is false, and the defendant being acquitted or convicted in a final judgment. Criminal liability obtains even if the false testimony was not considered by the court. We now discuss false testimony favorable to a defendant under Article 181. This covers the penalty for giving false testimony favorable to an accused person in a criminal case. The crime is characterized in People v. Reyes and is punished because it leads to an improper administration of justice. False testimony may be characterized by a negative statement if it favors the defendant. It need not directly influence the acquittal, and benefit to the defendant is not required. However, a false statement of opinion is insufficient to convict, unlike a statement of experience which is factual. A defendant who testifies falsely in their own behalf in a criminal case can be guilty of false testimony favorable to the defendant, especially if they falsely implicate another person. Furthermore, a spontaneous rectification of a mistake negates the crime of false testimony. Moving on to false testimony in civil cases under Article 182, the penalties depend on the amount involved in the controversy. The elements of false testimony in civil cases include testimony given in a civil case relating to an issue presented in that case. Note that Article 182 does not apply when the testimony is given in special proceedings. Additional elements require the testimony to be false, given knowingly, and to be malicious, with the intent to affect the issues presented in the case. The testimony must relate to the issue presented. We now address false testimony in other cases and perjury in solemn affirmation under Article 183. The law's policy on perjury aims to punish false swearing. Perjury can be committed either by falsely testifying under oath in a non-judicial proceeding or by making a false affidavit. The elements of perjury require the offender to make a statement or execute an affidavit upon a material matter. A material matter is defined as the main fact subject of inquiry, or a circumstance tending to prove or strengthen testimony on the subject of inquiry. There is no perjury if the lie does not relate to a material matter. Competent proof is required to establish materiality. Also, proof of pertinence is not sufficient to establish materiality. A key element of perjury is that the statement or affidavit was made before a competent officer authorized to receive and administer the oath. If the defendant subscribed and swore only before a clerk, there is no perjury. The statement must include a willful and deliberate assertion of falsehood. Good faith or absence of malice serves as a defense to perjury. Also, the sworn statement or affidavit must be required or authorized by law. 2 contradictory statements alone are insufficient to convict for perjury. The falsity must be proven by evidence other than the contradictory statement. Subornation to perjury means that the person procuring another to swear falsely is liable as a principal by inducement. If the person responsible for perjury is a public officer or employee, the maximum penalty applies, alongside a fine not exceeding 1 million pesos and perpetual absolute disqualification from public office, as incorporated by Republic Act No. 11,594. Finally, we cover offering false testimony in evidence under Article 184. The penalty is that for false testimony if committed in a judicial proceeding, or that for perjury if committed in an official proceeding. The elements include the offender offering a false witness or false testimony, knowing it to be false, in a judicial or official proceeding. Article 184 applies when the offender does not induce the witness to testify falsely. Otherwise, Arts 180, 181, 182, or 183 apply. This section covers machinations in public auctions under Article 185 of the Revised Penal Code. This includes the act of soliciting any gift or promise as consideration for refraining from taking part in a public auction. Key elements include the existence of a public auction, the accused soliciting a gift or promise, and the intent to reduce the price of the auctioned item. Another penalized act under Article 185 is attempting to cause bidders to stay away from the auction through threats, gifts, promises, or other artifice. This is consummated by mere attempt. The offender must have intended to cause a price reduction, but the threat itself does not need to be effective. Moving to monopolies or combinations in restraint of trade, Article 186 of the Revised Penal Code has been repealed. It is now superseded by the Philippine Competition Act of 2013, Republic Act No. 10,667. Republic Act No. 7,581, or the Price Act, penalizes price ceiling violations and illegal acts of price manipulation, such as hoarding, profiteering, and cartels. It was amended by Republic Act No. 10,623 to strengthen consumer protection and ensure stable prices for essentials during emergencies. Violation of price ceilings can involve 2 types of price control: automatic price control, triggered by the declaration of a state of calamity or emergency, and mandated price control. Mandated control requires presidential approval and is imposed when prevailing prices are rising to unreasonable levels. The reasonableness of price ceilings is determined by several factors, including the average price of the commodity in the 3 months preceding the proclamation, the commodity's market supply, and the cost of the producer, manufacturer, distributor, or seller. Illegal acts of price manipulation include hoarding. Hoarding is the undue accumulation of a basic necessity or prime commodity beyond normal inventory levels. The determination relies on definitions of basic necessity, prime commodity, and normal inventory levels. Prima facie evidence of hoarding includes basic or prime commodities being higher by 50% of the usual inventory. Other evidence includes the unreasonable refusal to sell or dispose of stocks from the usual channels of production, trade, commerce, and industry at the time of stock discovery. Profiteering is another illegal act of price manipulation, applicable only to specified basic and prime commodities. Prima facie evidence includes the absence of a price tag, misrepresentation of weight or measurement, adulteration or dilution, or a price increase of more than 10% in the preceding month. Cartels, defined as combinations or agreements of 2 or more persons engaged in the supply chain of basic or prime commodities, are also penalized. The agreement must be designed to artificially and unreasonably increase or manipulate the price. Prima facie evidence of a cartel includes uniform and complementary acts by competitors aiming to artificially or unreasonably increase prices. The requisites include 2 or more competing entities dealing with the same commodity, and their actions resulting in an artificial and unreasonable price increase. Evidence of a cartel can also be inferred from simultaneous and unreasonable price increases. The requisites here are 2 or more competing persons or business firms dealing with the same basic or prime commodity, and an actual simultaneous and unreasonable price increase thereof. The penalties for violation of price ceilings include criminal sanctions of 1 to 10 years imprisonment or a fine ranging from 5,000 Philippine pesos to 1 million Philippine pesos. Administrative penalties for price ceiling violations include a fine and additional sanctions such as temporary closure, reprimand, censure, suspension, revocation, or cancellation of permits, and other administrative sanctions under Executive Order No. 913. For illegal acts of price manipulation, criminal penalties are 5 to 15 years imprisonment or a fine from 5,000 Philippine pesos to 2 million Philippine pesos. Administrative sanctions include a fine and additional sanctions, which are the same as those for the violation of a price ceiling. We now transition to frauds in commerce and industry. Article 187 covers the importation and disposition of falsely marked articles made of gold, silver, other precious metals, or their alloys. The provision specifies the penalty and lists regulated articles, including gold, silver, other precious metals, and their alloys. The elements of this crime include the offender importing, selling, or disposing of any mentioned article or merchandise. Importing is separately punishable from selling. However, Article 187 does not apply to manufacturers of misbranded articles made of these precious metals or their alloys. A manufacturer who alters the quality or fineness of anything pertaining to their art or business is liable for estafa under the Revised Penal Code. Other elements are that the stamps, brands, or marks fail to indicate the actual fineness or quality, and the offender knows of this failure. Next is Article 188, covering substituting and altering trademarks, trade names, or service marks. This article has been repealed by the Intellectual Property Code. The punished acts include substituting a trademark or trade name for a real manufacturer or dealer and selling the same. Under Article 188, the substitution and selling must concur. Trade names, trademarks, or service marks do not need to be identical to the infringed mark, as colorable imitation is sufficient. However, differences must not be glaring or striking to the eye. We also define trade name and trademark, and the office or function of a trademark is identified. Further points under the repealed Article 188 are that trademarks may lose distinctiveness or become public property, and a service mark is defined. Other punishable acts include selling articles knowing the trademark was fraudulently used, using a substituted service mark, or reproducing a mark for fraudulent use. Republic Act No. 7394, the Consumer Act of the Philippines, contains penal provisions for consumer protection regarding product quality and safety, including prohibited acts and penalties. It also covers food, drugs, cosmetics, and devices, defining prohibited acts related to adulterated or unsafe products. The Consumer Act addresses adulterated drugs and devices, dangerous drugs, banned or restricted drugs, and adulterated cosmetics, with corresponding penalties. It also covers hazardous substances, outlining prohibited acts and penalties, with some exceptions. Additional spheres of regulation under the Consumer Act include sales acts and practices, practices related to weights and measures, and the regulation of repair and service firms. Various other penal provisions are found throughout the Act, and Article 169 addresses the prescription of actions or claims. Article 189 of the Revised Penal Code, concerning unfair competition and fraudulent registration, has also been repealed by the Intellectual Property Code. Acts punishable under this former article, now under the Intellectual Property Code, include selling goods that mimic a competitor's general appearance, which is defined as unfair competition. Unfair competition is penalized to protect the public and honest trade. The test for unfair competition is whether an ordinary purchaser is likely to be deceived. Elements include the offender giving goods the general appearance of a competitor's goods and offering or selling them with the intent to deceive. The general appearance can be shown in the goods themselves, their packaging, or other features. Mere offer for sale completes the crime, and the master is liable for the acts of servants. Although actual intent to deceive is an element, evidence of this intent is not necessary. Other acts include affixing a false designation of origin or false description to goods or services and selling them, as well as fraudulently registering a trade name, trademark, or service mark. Additionally, Republic Act No. 623 regulates the use of stamped containers, and smuggling is a related crime. Welcome to this video on Crimes Against Public Interest, the Architecture of Trust. We will be conducting a structural analysis of Title IV of the Revised Penal Code. Public interest is the invisible fabric of societal trust. The law penalizes these crimes because the integrity of the state's operational architecture is compromised. They are founded on 5 pillars: sovereignty, records, authority, justice, and economy. Pillar 1 focuses on forging the symbols of sovereignty, which include the Great Seal, the chief executive signature, treasury or banknotes, and coins. Crimes here directly attack the state's identity and fiscal stability. The anatomy of counterfeiting and forgery involves 4 stages: making or mutilating, importing, uttering, and possessing. Note that mere possession is not a crime, but unexplained constructive possession shifts the burden to the accused. Pillar 2 is the taxonomy of written truth. Documents are categorized as legislative, public, official, commercial, or private. For a crime to exist, the alteration must strictly change the document's meaning. Article 171 outlines the 8 methods of falsification, typically committed by public officers, employees, or notaries. Method 4, making untruthful statements in a narration of facts, requires 4 specific requisites. This diagnostic matrix differentiates public and private falsification. For public officers, Art 171, the role of damage is immaterial, as the crime is the violation of public faith. For private individuals, Art 172, damage is essential for private documents. Pillar 3, the impostor's mask, covers crimes against identity and authority, usurpation, false names, and illegal uniforms. Usurpation requires a positive, express, and explicit representation of authority. Pillar IV addresses the corruption of proceedings. False testimony can target criminal cases, civil cases, or occur through other affidavits, known as perjury. Article 184 is the central anchor, covering the offering of false testimony in evidence. The calibration of lies shows distinct penalties for false testimony against a defendant, favorable to a defendant, and in civil cases. Severity often depends on the potential sentence or the monetary amount in controversy. Perjury, under Article 183, requires 4 elements: the vehicle, the core, the authority, and the intent. The defense of good faith may apply if independent evidence of the falsity is absent and malice is negated. Pillar V focuses on market machinations and frauds. Machinations in public auctions, Art 185, subvert competitive bidding. Frauds in commerce, Art 187, concern the integrity of precious metals. The Price Act is a special penal law designed to protect basic necessities from artificial manipulation. Key offenses include hoarding, profiteering, and cartel formation, each having specific prima facie triggers. The Consumer Act, RA 7394, protects the public through quality and safety standards and penalizes food and drug violations. Unfair competition offenses under the Revised Penal Code have transitioned to the Intellectual Property Code. In synthesis, the ultimate victim in crimes against public interest is the invisible fabric of societal trust. The law enforces and, quote, ensuring that public faith, spanning sovereignty to economy, is never weaponized.
Welcome to The Explainer. I am so thrilled you're tuning in today, because we are going to explore something that is absolutely fundamental to our everyday lives. Seriously, just think about your morning for a second. You probably used some cash to buy a coffee, right? You trusted that the traffic cop directing you through the intersection was an actual officer, and you drove with a license that the state officially recognizes as valid. You know, society functions almost entirely on this really fragile, invisible fabric of trust. If we didn't have it, literally everything would just grind to a total halt. So today, we're going to look at exactly how the law steps in to protect that fabric. So, let me ask you a question to get us started. What do faking a driver's license and hoarding groceries actually have in common? Now, on the surface, I know they seem completely unrelated. I mean, one is maybe a teenager trying to sneak into a club, and the other is a business owner aggressively stocking up on rice during a typhoon. But here's the thing. In the eyes of the law, both of these actions absolutely destroy public trust. And that brings us straight into Title IV of the Philippine Revised Penal Code. So Title IV covers what we call crimes against public interest. These are offenses that are penalized specifically because they violate the public faith. They essentially destroy the truth that's solemnly proclaimed in our state systems. And the really crucial point I want you to take away here is that these aren't just crimes against one specific individual. If you forge a public document, the victim isn't just one person. The victim is the entire system of truth and reliance that you, me, and everyone else relies on every single day to function as a civilization.
Here is our roadmap for today's explainer. First, we'll cover faking state symbols and money. 2, falsifying the paper trail. 3, stolen identities in uniforms. 4, the crime of lying. And 5, rigging the free market.
All right, let's dive right into Section 1, faking state symbols and money. When we talk about forgeries, the law actually gets super specific. Let's clear up some of this legal jargon right off the bat, starting with the difference between counterfeiting and feigning. So counterfeiting is basically what we usually think of, right? Making an imitation of a genuine, already existing signature or coin. But feigning? That's a bit wilder. That's when someone creates a signature or a rubric that does not actually exist at all. Think about making it look like someone who literally doesn't even know how to write suddenly signed a legal document. Both are highly illegal because at the end of the day, both are injecting lies into a system that absolutely requires truth.
Now, what about the actual cash in your pocket? The Penal Code lays out some very specific crimes here. We've got making or importing false coins, deliberately mutilating legal tender, and forging treasury or banknotes. But there's also this one crime called uttering. Now, uttering sounds weird, but in legal jargon, it simply means passing off a fake coin or note to someone else. It's the act of physically putting that lie into circulation. And just a quick note, to be guilty of uttering, the offender generally has to have connived with the counterfeiters, or at the very least, known that the money was totally fake when they handed it over. To put this into perspective, let's look at some actual case law. It brilliantly shows how courts figure out if someone actually knew a bill was fake. So in one fascinating case, a person was caught literally snatching a forged 20 peso bill from someone who was examining it, and then tearing it to pieces. Naturally, the court saw that panicked conduct as crystal clear proof the person knew it was a forgery. And in another, honestly kind of amusing case, someone was convicted of forgery for taking an old 1 peso bill that had been withdrawn from circulation and just writing the word victory on the back of it to make it look like a true, genuine document. The law really doesn't mess around when it comes to protecting our currency.
Moving right along to Section 2, falsifying the paper trail. Okay, so under Article 171, we have falsification by a public officer. And the elements here are very, very structured. First, the offender has to be a public officer, an employee or a notary. Second, they have to take advantage of their official position. This basically means they already had official custody of the document, or it was their duty to intervene in it somehow. And third, well, they actually falsify it. A classic example from the syllabus is a public educator altering examination grades. I mean, they have the official capacity to record the truth, but they abuse that power to record a lie instead.
And this quote right here hits the nail on the head when it comes to our core theme. In the case of Damagas versus Milani, the court noted that the principal thing punished is the violation of public faith and destruction of truth as therein solemnly proclaimed. Notice what is totally missing from that sentence. Financial loss. Yep, when a public document is faked, actual financial damage or even just the intent to cause financial damage is totally immaterial. The crime itself is the destruction of the truth.
Which brings us to Section 3, Stolen Identities and Uniforms.
As you can imagine, the Penal Code takes identity deception extremely seriously. We're talking about usurping authority, concealing your true name to hide your identity, and the illegal use of uniforms. Now, have you ever wondered if using a pen name or an alias is actually illegal? Well, under the anti-alias law, you really do need court authority to use a substitute name. There are obviously exceptions made for literary, cinema, TV, or entertainment purposes, but if you're just publicly using a fictitious name to conceal a crime or cause damage to public interest, you are definitely crossing a major legal line.
Now, a really fascinating application of this involves uniforms. Check out this highly specific example from the syllabus. A layman publicly wearing the ecclesiastical habit of a Catholic priest to deceive other people. That actually falls squarely under Article 179 for illegal use of a uniform. And here is the kicker. An exact, perfect imitation of the uniform is not even necessary. If there is what the law calls a colorable resemblance that's calculated to deceive the common run of people, that's enough to trigger the law. It's all about the intent to falsely leverage the trust that society places in that specific uniform.
Okay, let's jump into Section 4, the crime of lying.
You know, we hear these terms thrown around a lot on TV crime shows, but let's actually define the strict legal boundaries here. What is the actual difference between false testimony and perjury? Well, false testimony is specifically when you testify falsely under oath inside a criminal or civil judicial proceeding, courtroom stuff. Perjury, on the other hand, is when you lie under oath on a material matter outside a judicial proceeding. Think along the lines of putting a deliberate falsehood in a sworn affidavit or lying on a civil service application. Both of these are absolutely toxic to the justice system. And if you happen to be a public officer who commits perjury, the stakes are staggeringly high. 1 million pesos. Yeah, you heard that right. Under Republic Act 11594, if a public officer or employee commits perjury, they face a fine of up to 1 million pesos. And not only that, they also face perpetual absolute disqualification from ever holding any government position again. The state places a massive premium on the honesty of its officials, and the punishment for breaking that trust is immense.
Finally, we reach Section 5,
Rigging the free market.
So we're moving from the courtroom straight into the aisles of your local grocery store. Republic Act 7581, which is known as the Price Act, protects consumers from illegal price manipulation, especially during big calamities or emergencies. And when the government needs to step in and mandate price control, they don't just pull a number out of thin air. They determine reasonable price ceilings through a very structured process. First, they look at the average price of the commodity over the last 3 months. Second, they assess the actual supply that's currently available in the market. And third, they calculate the real cost to the producer, manufacturer, or seller. It's a very balanced approach to make sure there's stability when the public is at its most vulnerable.
But what about the bad actors out there? Well, the law provides highly specific, quantified definitions, so there's really no gray area. Hoarding isn't just having a lot of stock in the back room. It is prima facie hoarding when you accumulate a basic necessity or prime commodity 50% beyond your usual inventory levels while unreasonably refusing to sell it. Profiteering, meanwhile, is triggered the moment you raise prices by more than 10% from the immediately preceding month. So the law gives us these exact thresholds to define exactly when normal everyday business practices mutate into a crime against the public.
And the big one, cartels. A cartel essentially destroys the invisible hand of the free market. For a cartel to exist legally, you have to have an agreement between 2 or more competing persons or firms that deal in basic or prime commodities. But the key element, the smoking gun really, is when they perform uniform and complementary acts to artificially and unreasonably increase or manipulate the price. When competitors secretly stop competing with each other and instead collude, they are literally ripping off the entire society by destroying market trust.
So, as we wrap up today's explainer, I want to leave you with a bit of a provocative question to chew on. If society's entire foundation really is trust, what happens when the fabric holding our money, our documents, our courts, and our markets together just unravels? The laws we explored today, they aren't just dry, boring rules in some old textbook. They are the essential defensive walls that protect the very reality we share. Every single time you accept a banknote, read a public document, or buy your groceries, you are relying on this invisible shield. I really hope this deep dive into crimes against public interest sparked some curiosity for you and gave you a brand new appreciation for the systems that keep our world spinning. Keep questioning, keep learning, and I'll catch you in the next explainer.
Imagine for a second that you are finally buying a house. You're sitting across from the seller. You sign that massive stack of contracts, and you hand over a cashier's check with basically your entire life savings.
Right, a huge moment.
Exactly. And the real estate agent smiles, they hand you the keys. But now, imagine a world where you walk out of that office and you suddenly realize you cannot trust that the money you just handed over will even be recognized by the bank.
Oh, wow.
You can't trust that the signature the seller put on the deed is legally binding. You drive home, a police officer pulls you over, and you genuinely cannot trust that the literal badge on their uniform isn't just like a prop bought from a costume shop.
That is it. I mean, that's a terrifying scenario.
It really is. What happens to you in that scenario? Like, what happens to society?
Well, it's a complete collapse. I mean, society essentially just grinds to an absolute halt. Because underneath all the complex machinery of the modern world, underneath the stock market, the justice system, even the morning commute you might be on right now, there is just one fragile, invisible ingredient keeping it all together. And that ingredient is trust.
Trust. Wow. And today we are going deep into exactly how a legal system ruthlessly protects that invisible glue.
Yes, we are.
Our mission for this deep dive is to take a journey into the anatomy of legal deception. We are looking at a specific framework within Philippine criminal law, a category designated as crimes against public interest.
It's a fascinating area of law.
It really is.
Yeah.
And we're going to trace this all the way from the highest level of sovereignty, forging the ultimate symbols of state power, all the way down to falsifying the everyday documents you sign.
Right, or stealing someone's authority.
Exactly. Lying under oath in a courtroom, and finally rigging the economic market that you and I participate in every single day.
And what we really need to establish right away is that we aren't just talking about a simple scam here.
How do you mean?
Like if someone tricks you out of $20 on the street, that's a crime against you personally.
Yeah.
That's just theft or fraud.
Right.
But the legal doctrines we're exploring today, they are crimes that strike at the very heart of the state and the public faith. The victim isn't necessarily a specific person. The victim is the system itself.
This system. Okay, I want to frame this with an analogy because the scope of these laws is just massive.
Sure, Go for it.
Think of society like a massive multiplayer online game. You have millions of people logging in, interacting, trading, building things together.
Okay, I like that.
Now, the laws against murder and theft, those are the basic rules of the game. You can't attack another player.
Right, the basic terms of service.
Exactly. But the legal framework we are looking at today, these crimes against public interest, they aren't just rules about player versus player theft. They are the anti-cheat software.
Oh, that's a great way to put it.
They are the fundamental underlying code that keeps the entire game from breaking down and becoming, completely unplayable for everyone.
Because if the game doesn't recognize its own currency or its own official decrees, the server basically shuts down.
Right. Game over.
Exactly. Which is why the highest form of forgery, like the absolute peak of this anti-cheat software, deals with counterfeiting the state itself.
Before it even looks at the market.
Right. Before the law even bothers to look at how individuals deceive each other in the marketplace, it looks at how individuals attempt to deceive the state.
And the framework starts right at the very top, doesn't it? Forging the Great Seal of the government of the Philippines, or forging the signature or stamp of the chief executive, the president.
The ultimate authority.
Yeah, and there is a very strict legal distinction here that caught my attention immediately. If someone forges a regular contract, they are charged under the general umbrella of falsification.
True.
But if you forge the president's signature, it gets pulled out of that general category and becomes its own specific, highly penalized crime. Why this special treatment? Is a signature not just a signature?
Well, not when it comes to the chief executive. To understand this, you really have to look at the philosophy of sovereignty. The Great Seal and the signature of the president, they are the ultimate authenticating marks of the state's power to govern.
So it's more than just ink.
Oh, absolutely. The administrative codes specifically dictate the custody and use of the Great Seal because it isn't just an administrative stamp. It is the physical manifestation of the nation's will.
Wow.
If you, as a regular citizen, falsify a business contract, you're harming the other party involved in that specific deal. But if you falsify the president's signature,
You're doing something way bigger.
you are essentially usurping the power of the republic. You're creating a parallel reality where you get to dictate state policy.
Right.
The law recognizes that this is a direct attack on the integrity of the sovereign nation itself.
So the severity of the punishment basically scales with the existential threat to the state.
Exactly.
And the net is cast incredibly wide, too. The law doesn't just go after, the master forger sitting in a dark room with specialized ink.
No, it doesn't.
It aggressively pursues the person who simply uses the forgery. If you knowingly make use of that counterfeit seal or forged signature, even if you had absolutely nothing to do with creating it, you are treated as an accessory. And the penalty is only 1 degree lower than the forgers.
The mechanism the state uses here is containment. Think of a forged presidential decree like a virus.
Okay.
The person who coded the virus is dangerous, yes, but the person actively spreading it, they are the immediate threat to the public.
But that makes total sense.
However, the prosecution does carry a heavy burden here. They have to prove that the user knew the document was forged.
So intent matters.
Yes, you can't be penalized if you were just an innocent actor who was, duped into delivering a fake state document.
Got it. Okay, let's move from the president's pen to the money in our wallets. We're talking about counterfeiting coins, treasury notes, and banknotes.
Right, the lifeblood of the economy.
And I should point out, the legal framework explicitly includes foreign currency here, which makes total logical sense because if you introduce millions of fake US dollars or fake euros into a domestic economy, the chaos doesn't respect borders.
It really doesn't.
But there is a specific legal doctrine regarding coins that I found incredibly counterintuitive. Let's call it the obsolete coin rule. And it's rooted in some fascinating jurisprudence.
Oh, this is one of the most brilliant pieces of legal reasoning in the entire penal code.
Really?
Yeah, it almost always trips up law students the first time they encounter it.
Right, so let's break this down for the listener. The jurisprudence establishes that the law heavily punishes counterfeiting even for former coins that have been entirely withdrawn from circulation.
Yes, coins that are no longer legal tender.
We are talking about coins nobody uses. If you went into a coffee shop right now and tried to pay with, a Spanish real from the 1800s, the barista would just stare at you.
They'd have no idea what to do with it.
Exactly. So if nobody uses these coins to buy anything anymore, why is it a crime against public interest to counterfeit them? Where is the actual threat?
To answer that, We have to look closely at the Supreme Court's rationale in a landmark case regarding this exact issue. It's called People versus Ting Ching Ting.
Okay, ting ching ting.
The court's reasoning there is just an absolute masterclass in understanding the nature of criminal capability.
Capability.
Yes. The law does not punish the fabrication of an obsolete coin simply because of the minor economic harm if, say, that weird old coin somehow manages to get traded to a collector.
Right, because it's not disrupting the morning commute economy. Nobody's buying gas with it.
Precisely. The real danger, the reason the state steps in with the full force of a felony charge, is the psychological and physical capability of the counterfeiter.
What do you mean by that?
The state looks at this person and says, you are practicing your trade. If an individual can successfully source the metals, build the dies, and mint a convincing fake obsolete coin.
They have all the skills.
Exactly. They possess the tooling, the metallurgy skills, and the criminal intent necessary to disrupt the modern economy. It is only a matter of time before they retool their machines and apply that highly specialized trade to minting coins that are in actual current circulation.
Oh, I see.
The state is punishing the capability and the imminent threat to the public monetary system.
Okay, I want to push back on this boundary a bit just to map out exactly where the line is drawn.
Sure, lay it on me.
Let's say I don't set up a minting press. Let's say I'm just sitting at my kitchen table and I take a regular, completely valid copper cent, an everyday penny,
Okay.
and I take some chemical treatments or like metallic paint, and I alter that penny so it gets the appearance of a silver piece, say a quarter or a peso coin.
A painted penny.
Right. I then take that altered shiny coin to a busy convenience store and try to trick a distracted cashier into giving me a candy bar. The legal precedents are very clear that giving a copper cent the appearance of a silver piece with the attempt to use it is considered fraud, estafa.
Yes, that is correct.
It is explicitly not considered counterfeiting.
Correct again.
But wait, if I paint a penny silver and try to buy gum, that's just regular run-of-the-mill fraud. But if I use heavy machinery to mint a fake coin from the 1800s that no one has used in a century, I'm suddenly a counterfeiter facing a huge crime against public interest.
Yep.
Why is the obsolete coin considered a bigger threat to the state than the painted penny that I am actively using to steal from a store?
This is the perfect hypothetical to illustrate the difference between tricking a person and tricking a system.
Okay, walk me through it.
When you paint a copper coin silver, you aren't creating currency. You are taking a piece of existing state-sanctioned currency and altering its superficial appearance to deceive one specific human being, the cashier.
So it's just a targeted scam.
Exactly. You're committing a targeted fraud against that individual. But when you fabricate a coin from scratch, even an obsolete one, you are doing something much more profound.
Because I'm making it from nothing.
Yes. You are usurping the state's exclusive monopoly on creating money. You are basically building an independent mint. The painted penny is just a parlor trick to steal 50 cents. The fabricated obsolete coin is a declaration that you can manufacture reality.
Manufacture reality. So it all comes back to the monopoly on reality.
Yeah.
Now, what about mutilation? The laws cover mutilating coins of legal currency with the intent to defraud.
Right.
This brings to mind the historical practice of, coin clipping, shaving the precious metals off the edges of gold or silver coins, which, by the way, is why modern coins have those rigid edges to show they haven't been shaved.
That's a great historical point, yeah.
Interestingly, though, foreign coins are explicitly excluded from this specific mutilation rule.
And that exclusion reveals the state's primary directive. The government's job is to protect the physical integrity of its own circulating wealth.
Right.
If you take a foreign coin and file down the edges to harvest the silver, you might be committing fraud if you try to pass it off to someone at its original weight. But you aren't degrading the physical integrity of the domestic monetary supply.
I see.
The law is fiercely protective, but its jurisdiction over physical degradation basically ends at its own legal tender.
And this protective shield extends far beyond metal coins, right? The framework deeply covers the forgery of treasury or banknotes and any obligations and securities payable to the bearer.
Yes, we are talking about bonds, certificates of indebtedness, national banknotes, coupons.
I want to highlight that phrase you just used, payable to bearer. This is a crucial legal concept.
It really is.
It means the instrument is negotiable by mere delivery. Like, if you are listening to this and you have a $100 bill in your pocket, it doesn't have your name on it. Whoever physically holds the paper holds the value.
Exactly. That anonymity and ease of transfer make bearer instruments highly susceptible to forgery. which is why the penalties for faking them are so incredibly severe.
The jurisprudence also points out that the exact type of document dictates the exact criminal charge. There's a case, People versus Sampson, which clarifies that standard checks issued by a national bank are considered commercial documents, not treasury notes.
The state draws incredibly fine lines there.
They really do. And just like with the state seal, illegal possession and use of these false treasury notes is heavily punished. If you have a stack of fake cash and you know it's fake, and you hold it with the intent to distribute it, you are committing a crime.
But proving that internal knowledge, that's where prosecutors earn their paychecks.
Because you can't read a defendant's mind.
Right, because you can't read minds, the courts look entirely at conduct. How did the person behave when the authenticity of the money was questioned?
Like, did they act guilty?
Exactly. For instance, in one notable case, the owner of a forged bill was showing it to someone, and when that person started examining it a little too closely, the owner snatched it back and immediately tore it to pieces.
A completely natural reaction for an innocent person, obviously.
Right. Totally normal. Or consider another case where police were executing a search warrant. The suspect adamantly denied having any counterfeit bills in his possession, telling the police, "I don't have fake money, I just have this unlicensed illegal revolver."
Ignore the fake cash, officer. Just arrest me for the illegal firearm.
That is an absolutely spectacular defense strategy.
Didn't work out too well for him.
I can't imagine. Okay, so we've covered the physical metal, we've covered the ultimate seals of the state, but as society has evolved, the vast majority of our trust doesn't live in metal coins anymore.
No, it doesn't.
It lives on paper. It lives in documents. Which brings us to a massive transition in our deep dive today. The power of the pen, falsification of documents. If trust is the invisible glue of society, documents are the operating system.
I love that analogy. And just like a computer operating system, the legal framework recognizes different levels of administrative access and different types of files.
How so?
Well, the law draws an incredibly sharp, unyielding line between public documents and private documents. And where a document falls on that line dictates everything about how a crime of falsification is prosecuted.
Okay, let's lay the groundwork and define those, because the implications are massive here. A public document is something executed by a public official or a notary public, functioning in response to the demands of public service.
Right.
So think about your burial permit, your driver's license, an official government cash book, or a receipt for taxes collected. The state's fingerprints are all over it.
Yes, exactly.
A private document, on the other hand, is a deed or an instrument executed entirely by private persons, without any intervention by a notary or official.
Right.
So if you scribble a contract on a napkin to buy your neighbor's lawnmower, or you hold a theater ticket, those are private documents.
The nature of the document is the first variable. The second variable is the identity of the person holding the pen.
Who is doing the writing?
Yes. The law places a much heavier burden on public officers, employees, or notaries who take advantage of their official position to falsify a document.
Makes sense. They hold the public trust.
Right. And the jurisprudence categorizes the ways officials can commit this crime into several distinct buckets, ranging from counterfeiting handwriting to attributing false statements to someone.
I want to zero in on one of those specific buckets because it sounds simple, but the legal reality is incredibly complex.
Yeah, which one?
The law penalizes a public official for making untruthful statements in a narration of facts.
Ah, yes.
On the surface, that just sounds like lying on a piece of paper. But legally, it is highly nuanced, isn't it?
Oh, highly nuanced. Because for this specific act to be considered the crime of falsification, there must be a pre-existing explicit legal obligation for that person to disclose the truth of the facts narrated.
Okay, so to clarify, if I keep a personal diary and I write down that I am 8 feet tall and can fly, I am narrating untruthful facts.
You are.
But I'm not committing a crime because the state doesn't require my diary to be legally accurate.
Exactly.
Yeah.
But it goes beyond diaries and into serious administrative realms. There are cases where individuals fail to disclose, say, foreign equity in a corporation during its formation, or omitted a previous minor conviction on a personal data sheet.
And what happened?
If the specific law governing that exact form does not explicitly require the disclosure of that specific fact at that specific time, omitting it might be ethically questionable, but it is not the crime of falsification. Wow. The strict legal obligation to disclose acts as the trigger. But if an official is legally mandated to issue a certification containing the exact truth, say certifying the results of an election or the disbursement of funds, and they lie on that form,
That's a different story.
that is a direct catastrophic hit on public interest.
Let's shift from corrupt officials to regular citizens then. And this is where my mind got completely spun around when looking at the legal theory, specifically regarding the concept of damage.
Yes. The presence or complete absence of damage.
Right. The jurisprudence establishes that when a private individual falsifies a public document, actual damage, meaning someone...
Therefore, the crime in falsifying a public document isn't about stealing money. It is a violation of public faith. The moment you alter a public record, you have introduced a virus into society's operating system.
So the damage is to the trust itself.
The damage to the public trust is instantaneous and absolute, whether or not a single dollar changed hands.
So the document itself is basically sacred.
Yes. But a private document, like that theater ticket or the napkin contract for the lawnmower, only affects the private parties involved.
Right.
If you alter your own copy of a private contract and just leave it locked in your desk drawer, you haven't harmed the public faith. Society doesn't care about your lawnmower. The state only steps in and criminalizes the act if you take that altered private document and actually use it to defraud or damage another person.
The destruction of truth. That phrase carries so much philosophical weight, and it leads us directly to what I consider the most fascinating legal paradox we're going to talk about today. Let's call it the truth exception.
Okay, I love this one.
So, I want you to walk me through this hypothetical. Let's say I am looking at an official public government contract. It is a completely genuine document.
Right.
But as I read it, I notice there is a blatant, undeniable typographical error in the date. The contract says it was executed in 2014, but everyone in the room knows it was absolutely signed in 2024. It's a clear typo.
A simple mistake.
Right. If I pull a pen out of my pocket, cross out the 1 and write a 2, so the document now accurately reads 2024, have I committed the crime of falsification by physically altering an official document without authorization?
Under the framework established by the landmark Cabagos versus People ruling, you have not committed criminal falsification.
Wait, really? But I just took a pen and physically defaced a public document.
You did. And you might face administrative sanctions for mishandling government property, or you might get fired for violating office protocols.
Okay.
But you have not committed the criminal felony of falsification. Because as we establish, the core essence of the crime is the destruction of truth. If a document contains a falsehood, a typo, an error, a mistake, and you alter the physical document so that it now speaks the actual objective historical truth, you cannot be convicted.
Because it's now true.
Exactly. You haven't destroyed truth, you have restored it. The malicious intent to pervert reality is completely missing.
So essentially, the law prioritizes metaphysical truth over the physical integrity of the paper itself. The state cares more about what the document represents than the ink on the page.
That is a beautiful way to synthesize it. However, the law also recognizes that truth can be destroyed without malicious intent.
What do you mean?
You don't always need a criminal mastermind deliberately changing dates to commit falsification. The law can punish you for accidentally destroying truth through reckless imprudence.
Wait, how do you accidentally commit falsification?
Well, the jurisprudence gives us the example of a hospital director, in case known as People versus Balmas.
Okay.
This director signed off on official billing documents that contained heavily overstated numbers regarding patient hospital stays.
Oh, wow.
The investigation proved that the director didn't intentionally inflate the bills to steal money. He wasn't running a scam, he was just incredibly busy, and he relied entirely on the reports generated by his subordinates. He just signed the documents without implementing any verification process.
He essentially said, I didn't read it, I just signed what was put in front of me.
And the court ruled that when you hold a position of authority, your signature is not just a formality. It is a guarantee of public faith. You have a duty of care.
And he failed that duty.
Exactly. Neglecting that duty so severely that massive falsehoods become official government record is a crime against public interest. You are found guilty of falsification through reckless imprudence.
So ignorance is not a shield when you wield public authority.
Not at all.
And it's important for the listener to know that this framework extends far beyond paper, too. The laws cover the falsification of wireless, cable, telegraph, and telephone messages.
Digital stuff, basically.
Yeah. Right. Like if a telegraph operator maliciously changes the word count on a message to pocket the difference in the transmission fee, that is a crime against public interest.
Definitely.
It also covers false medical certificates. If a physician issues a fake medical certificate to help someone skip work, or a public officer issues a fake certificate of good conduct, the state treats that as a severe breach of trust.
It's all about maintaining that baseline of faith in official declarations.
Exactly. Okay, so we've covered faking the money. We've covered faking the paper. But what happens when you decide to fake yourself?
Now we're getting to the fun stuff.
Right. This transitions us to the next massive pillar of public interest law, stealing identity and authority. We are entering the realm of imposters, aliases, and uniforms.
This section shifts from the administrative to the deeply personal, because it deals with how individuals present themselves to the world and how society regulates that presentation to prevent total chaos.
The core concept here is usurpation of authority or official functions. This is defined as performing acts pertaining to a person in authority without being legally entitled to do so under the pretense of official position.
Right.
Now, most people hear that and imagine like a civilian buying a fake police badge and pulling people over.
Yeah, that's the classic movie trope.
But the jurisprudence gives a much more nuanced political example. It details a case where a public officer actually usurped the authority of another public officer.
Yes, the Hilvano case.
Exactly. There was a city councilor who was temporarily designated as the acting mayor, but when the rightful vice mayor eventually arrived to take their legally mandated seat, the councilor flat out refused to give up the office.
That specific case, People versus Hilvano, perfectly illustrates that usurpation isn't just about putting on a costume. It's about the illegal exercise of power.
Because he already had the office.
Right. The counselor wasn't an imposter in the traditional sense. He had colorable authority initially. He was legally allowed to be acting mayor for a time. But the moment the legal right shifted to the vice mayor, his continued exercise of mayoral functions transformed into criminal usurpation. He was actively stealing the authority that the public had vested in someone else.
That is fascinating. And that brings us to the concept of the name itself, using fictitious names and concealing true name.
A very tricky area of law.
The law strictly prohibits using a name other than your real one to conceal a crime, evade a judgment, or cause damage to public interest. But as I look at the legal text, there is a massive neon flashing adverb that seems to control the entire application of this law.
Yes. The word is publicly.
Publicly.
To violate this law, the offender must use the fictitious name publicly.
And this singular word leads us to what is arguably the most famous or perhaps infamous case study in this entire legal area, the Joseph Estrada exception.
Oh, yes. This one is a classic.
For the listener who might not be familiar, former Philippine President Joseph Estrada was scrutinized for signing a bank trust document using the alias Jose Velarde.
That's the one.
Now, I want to look at this neutrally, purely as a mechanical legal puzzle. How is it possible that a Supreme Court could look at a high-profile figure signing a fake name on a banking document and rule that it was not a public use of an alias?
It is a phenomenal example of what happens when two powerful laws collide head-on at high speed.
How do you mean?
Well, on one side of the collision, you have the Penal Code, which strictly punishes the public use of a fictitious name. On the other side, you have Republic Act number 1405, the Bank Secrecy Law.
Ah, the ultimate privacy shield.
Precisely. The Supreme Court analyzed this collision in People versus Estrada. The Bank Secrecy Law dictates that bank deposits are statutorily protected zones of privacy.
Okay.
The court ruled that when you sit in a bank manager's office and sign documents to open a trust account, even if there are bank employees physically in the room watching you sign it, that act is inherently legally private.
Because of the bank context.
Yes. The Bank Secrecy Law throws an impenetrable cloak of confidentiality over the entire transaction. Therefore, the court reasoned, because the transaction is statutorily mandated to be strictly private, it is legally impossible for the prosecution to claim that the alias was used publicly.
Wow.
The law against aliases just hit a brick wall when it met the absolute privacy of the banking sector.
So, if we break that down, the definition of public isn't determined by whether another human being is looking at you. It is entirely defined by the legal environment you are standing in.
Exactly.
A bank vault is a legal black hole for the word publicly. That completely changes how you understand physical reality in a legal context.
And it highlights how the law is highly sensitive to context, which perfectly segues into the next issue. the illegal use of uniforms or insignia.
Right. The law punishes anyone who publicly and improperly wears uniforms or dresses of an office they do not hold. And it notes that an exact stitch-for-stitch imitation isn't needed. A colorable resemblance calculated to deceive the common run of people is enough.
It just has to look convincing enough.
Now, I have to ask the obvious practical question here. If I dress up as a police officer, or, since the jurisprudence explicitly mentions a layman wearing a priest's habit, if I dress up as a Catholic priest for a stage play or a Halloween party, am I violating the law? Does my intent matter? Or is the outfit alone illegal?
Again, we have to look incredibly closely at the adverbs the legislature chose.
Ugh.
Publicly and improperly.
Okay, there's that word again.
If you are an actor on a stage in a theater, or you are at a private Halloween party, the context makes it immediately clear to the common run of people that you're wearing a costume.
Right. Nobody thinks I'm actually a priest at a Halloween party.
Exactly. There is no calculated deception of the public faith. The crucial requirement is that you must be wearing the uniform improperly, meaning you're wearing it in a manner that implies you actually hold the office, with the active potential to deceive people into treating you as an authority figure.
So it's about the context of the deception.
Yes. If you walk into a hospital wearing a fake doctor's coat and start asking for patient records, that is improper, calculated deception, and highly illegal. If you wear it to a costume party, the legal threat to the public interest is zero.
Good to know our Halloween traditions are safe from felony charges.
Definitely safe.
So we've covered faking identities out in the streets, but what happens when you take those fake identities or fake facts into the ultimate arena of trust?
The courtroom.
Yes. We are moving into weaponizing the truth. We're talking about false testimony and perjury.
The courtroom is the sacred space where society relies entirely on sworn testimony to literally take away people's property or their freedom. If you pollute this specific environment with falsehoods, the entire adversarial justice system breaks down.
The framework categorizes this meticulously. Let's look at false testimony against a defendant. The legal notes show that the penalty for this crime depends entirely on the sentence the defendant is facing.
Right, it scales.
So, if I maliciously lie on the stand to frame my neighbor for a minor parking violation, my penalty is minor. But if I lie to frame them for murder and they are facing life imprisonment, my penalty is massive.
Yes, the punishment scales proportionally with the danger you put the victim in.
That is a very clean, logical structure. But then we get to the flip side. False testimony favorable to a defendant.
This is where it gets interesting.
Right. This is lying under oath to help someone, and the law still comes down incredibly hard on this. The jurisprudence establishes that even a negative statement like a witness saying, "No, I didn't see him at the crime scene when they actually did," counts as false testimony.
It absolutely does.
It even states that the testimony doesn't need to directly influence an acquittal. Actual benefit to the defendant isn't even required. But if I'm just trying to save a friend from going to jail and my lie doesn't actually end up helping them anyway, where is the harm? Who is the victim?
The victim is the concept of truth itself, and by extension, the state's ability to administer justice.
Oh, I see.
You have to look at the underlying philosophy of the justice system. A criminal trial is not a game to see who wins or loses. The singular purpose of a trial is the discovery of truth.
Right.
When a witness places their hand on a Bible or swears an oath and then introduces a deliberate lie into the official record, even a lie meant out of loyalty or compassion to save a friend, they are actively corrupting the machinery of justice.
They're breaking the system.
They are forcing the judge to weigh poisoned evidence. The crime against the public interest is the pollution of the process, completely regardless of the final verdict.
The integrity of the process is more important than the intent of the witness.
Exactly.
Now, let's step outside the actual criminal courtroom. The laws cover perjury. This is defined as testifying falsely under oath outside a judicial proceeding or making a false affidavit. Like if you sign a sworn statement and lie.
Right, like an affidavit.
But here we get into a critical legal distinction that determines whether someone goes to jail or not. The lie must be on a material matter.
Yes. This is the crucial difference in legal terminology between materiality and pertinence.
Right. And the jurisprudence provides a really clarifying example from a case called People versus Banzol.
I know that one.
Let's say a person is charged with immorality in an administrative proceeding. In their sworn affidavit defending themselves, they deliberately lie about their civil status or their exact residence.
Okay.
Now, those lies might be slightly pertinent to their background, but they don't actually prove or disprove the core charge of immorality. Because the lie isn't the central issue, it is not considered a material matter, and therefore it is not perjury. It has to actually affect the core issue of the inquiry.
Exactly. If the lie, no matter how blatant, cannot logically influence the outcome of the specific inquiry being conducted, the law does not elevate it to the severe crime of perjury.
So lying isn't always perjury.
Right. It might destroy your credibility as a person, but it isn't a weaponized lie that threatens the legal proceeding itself. I should also mention the concept of sublimation of perjury here. If you procure someone else to swear falsely, you become a principal by inducement. You don't have to be the one taking the oath or sitting in the witness chair to be guilty of the crime. If you engineered the lie, you are responsible for polluting the truth.
Which brings up a really fascinating epistemological question about what actually constitutes a lie under oath. Let's look at the precedent set by the U.S. versus McGovern case.
Okay, the McGovern case.
Let's say a witness gets on the stand. They swear an oath to tell the whole truth. They then puff out their chest and confidently claim to the jury that they are a highly experienced handwriting expert.
Okay, setting the scene.
But in reality, they have no formal credentials, they are completely self-taught from watching YouTube videos, and they are essentially just making it up to sound important. Have they committed false testimony?
According to the Supreme Court's ruling in McGovern, no, they have not.
Wait, really? But they lied.
Well, that statement alone is not sufficient to convict for false testimony. And the reasoning goes to the core of how evidence works. When the witness characterized himself as an expert, he was making a statement of opinion. He genuinely holds the subjective opinion that his self-taught skills make him an expert. False testimony and perjury require the willful assertion of a false objective fact.
So if the witness said, I have a PhD in forensic graphology from Oxford University, and they don't, that is a verifiable fact, that is a lie, and that triggers a perjury charge.
Precisely. Claiming an academic degree is a factual assertion. Claiming I am an expert is subjective puffery.
That is a huge distinction.
It is. The system is designed to handle puffery. It is the opposing counsel's job to cross-examine that witness, expose their lack of credentials, and prove to the jury that their opinion is utterly worthless.
Right, let the lawyers fight it out.
Exactly. But holding a heavily inflated subjective opinion of your own skills, even while under oath, is not a criminal attack on the public interest.
The precision required by these laws is just astounding. Okay, we are leaving the courtroom and we are walking out into the streets and the grocery stores. We are entering our final section, rigging the everyday economy, frauds, prices, and consumers.
The real world.
Exactly. How does the law protect the public trust when you go to buy a sack of rice, bid on an item, or run a business?
This is where the esoteric concepts of public interest intersect violently with our daily survival and basic economic fairness.
Let's start with machinations in public auctions. The law strictly penalizes anyone soliciting gifts or making promises to refrain from bidding or attempting to cause other bidders to stay away by threats or artifice.
Right. Bid rigging.
It's essentially criminalizing the rigging of a public sale to artificially suppress the price of an asset. But the real everyday impact of this section is found in the special laws, specifically Republic Act 7581, known as the Price Act.
A very important piece of legislation.
It really is. This law is designed to regulate basic necessities and prime commodities, and it targets three specific economic monsters: hoarding, profiteering, and cartels.
And what is crucial for you, the listener, to understand here is that the law doesn't rely on a vague, subjective feeling of prices are too high right now.
It's not just a vibe.
No, not at all. The legislature built very strict numerical triggers into the law to objectively define when a market fluctuation becomes a crime.
Let's break those numerical triggers down. Hoarding isn't just buying an extra bag of rice because you're hungry. The law defines it as the undue accumulation of stock beyond normal inventory levels.
Right.
Specifically, it states that having stocks that are 50% higher than your usual inventory, coupled with an unreasonable refusal to sell those goods to the public, is prima facie evidence of hoarding.
That's the threshold.
Profiteering has its own mathematical trigger. It is defined as raising prices by more than 10% from the previous month. It also covers selling goods without a price tag, misrepresenting the weight of an item, or adulterating the goods to make them seem heavier or better quality.
Right, tricking the consumer.
And cartels are defined as two or more competitors performing uniform and complementary acts to artificially manipulate and increase prices.
Working together to gauge people.
Right. Now, I want to construct a hypothetical scenario to test the boundaries of the hoarding provision, because that 50% inventory trigger seems incredibly strict.
Okay, let's hear it.
Let's say I am a small grocery store owner in a coastal town. I watch the news and I hear that a massive Category 5 typhoon is going to make landfall in exactly 1 week.
A very realistic scenario.
Definitely. I know my community is going to be desperate for supplies, so to ensure I don't run out, I call my distributor and I immediately buy double the amount of canned goods, bottled water, and batteries. My inventory is now 100% higher than normal, which blows right past the 50% trigger in the Price Act. By trying to prep my store for a disaster, am I suddenly a criminal hoarder facing jail time?
It is a vital question because the state has absolutely no interest in criminalizing good business sense or community preparation. The critical phrase in the law is unreasonable limitation or refusal to sell.
Unreasonable limitation.
Right. You mentioned that the 50% jump is prima facie evidence. In legal terms, that means it looks like hoarding at first glance, and it gives the authorities the legal right to audit your store and investigate.
Yeah.
But it is a rebuttable presumption.
Meaning I have the right to explain the context to them.
Exactly. If the inspectors come and you can show them that you bought the extra stock specifically to ensure your shelves remained full for your customers during the typhoon, and you are actively selling those goods at normal, non-exploitative prices, you will not be charged.
Oh, good.
Criminal hoarding requires the malicious intent to restrict supply in order to artificially manipulate the market price. You are doing the exact opposite. You are trying to ensure steady supply.
That makes a lot of sense. The mathematical trigger just starts the investigation, but the context determines the crime.
Precisely.
What about the 10% jump for profiteering? Because prices fluctuate all the time. Are there exceptions to that strict 10% cap?
Yes, the law has to account for reality. It specifically exempts agricultural and seasonal products from the strict 10% rule because the prices of those goods fluctuate naturally and violently based on harvest, weather conditions, and supply chain issues.
Because farming is unpredictable.
Right. You cannot penalize a farmer or a vendor because a severe drought made mangoes scarce and drove the price up 20%. The law is specifically targeting the artificial, malicious manipulation of manufactured basic necessities.
Okay, wrapping up the marketplace, the framework covers frauds in commerce. It severely penalizes falsely marking the fineness or quality of gold, silver, or precious metals.
Yeah, you can't fake gold.
Right. If a jeweler imports or sells a ring stamped as 24 karat gold, but they secretly know it's only 10 karat, they are violating the public interest. And then there is the concept of unfair competition.
This is a really interesting one.
Now, the jurisprudence notes that some of these specific articles were repealed and subsumed under the modern intellectual property code, but the core mechanism of the crime remains identical. And it's fascinating because it's not just about stealing a logo or a brand name.
No, it's broader than that.
The crime is giving your goods the exact general appearance of a competitor's product to deceive the public.
Yes, the courts look at the totality of the presentation. The general appearance includes the shape of the goods, the style of the wrapping, the packaging materials, the specific font used, the color palette.
Everything combined.
Right. If you manufacture a cheap, substandard soap, and you design the box to look practically identical to a highly trusted premium brand, hoping to trick a rushed shopper into grabbing it off the shelf, that is unfair competition. And the law is incredibly aggressive here. The mere offer for sale of a copycat item completes the crime.
Wait, so you don't even have to actually trick anyone or make a profit?
No. You don't have to successfully sell a single unit. Just putting the deceptive item on the physical shelf or listing it in a catalog with the intent to deceive the public is enough to trigger the felony.
Because you have introduced a lie into the marketplace.
Exactly.
And all of this is ultimately backed up by the Consumer Act, Republic Act 733/94, which acts as a massive safety net protecting consumers against adulterated food, poisonous ingredients, unsafe drugs, and regulating the exact weights and measures used in commerce.
It's all connected.
It really is.
Okay, let's take a breath and zoom out. We have covered an incredible amount of ground today. If you are still with us, think about the journey we just took.
It's been a long ride.
We started at the absolute peak of sovereignty, looking at the Great Seal of the Republic and the president's signature. We moved down into the physical coins in our pockets, exploring why minting a century-old coin is a greater threat than painting a penny.
Right.
We explored the operating system of paper, learning how altering a date on a document can destroy truth unless it actually fixes a typo to restore truth.
The truth exception.
Exactly. We talked about the psychological weight of slipping on a fake uniform, the paradox of signing bank documents under the cloak of privacy, the danger of lying under oath even to save a friend, and finally, the mathematical triggers used to prevent the rigging of grocery prices during a typhoon.
It's a massive framework.
All of these incredibly diverse, seemingly disconnected actions, from forging the Great Seal to hoarding rice, are tied together by one single unbreakable thread.
They are all crimes against public interest.
Yes, they all exist to maintain that invisible safety net of trust that allows our massive multiplayer game of society to keep running.
And as we conclude this deep dive, I want to leave you, the listener, with a final provocative thought to mull over.
Oh, I'm ready. As we've seen today, all of these intricate laws, all of these precedents about what constitutes a document, a signature, a uniform, or a counterfeit coin, they were all designed and written for a fundamentally physical world.
Right. Ink and paper.
They rely on physical seals, physical ink, physical cloth, and physical metals. But look at the horizon of where society's going. We are rapidly moving into a world dominated by artificial intelligence.
Oh, wow. Yeah.
We are entering the era of deep-faked video testimony, where a witness could appear to be on the stand saying things they never said with absolutely perfect visual and audio fidelity.
That's terrifying.
We've digitally altered identities, blockchain smart contracts, and synthetic voices that can perfectly mimic a CEO or even a president giving a legally binding order over the phone.
Which completely blows past the idea of just forging a signature.
Exactly. The very definition of what constitutes a document or a signature is shifting rapidly beneath our feet.
So what happens to the law?
That's the question. How will our legal system, which has spent centuries relying so heavily on physical evidence and the ability to gauge human intent in a physical room, redefine the concept of trust when the evidence of our own eyes and ears can be perfectly and seamlessly counterfeited by code?
That is wild to think about.
That is the next great frontier of crimes against public interest.
That is a terrifying and honestly, utterly fascinating thought to end on. It seems the anti-cheat software of society is going to need a massive fundamental update very soon.
Without a doubt.
Well, thank you so much for joining us on this incredibly detailed deep dive. Next time you sign a contract, hand over a coin, or look at a price tag in the store, take a moment to appreciate the massive, invisible architecture of law that makes that simple transaction possible. Keep questioning the world around you, and we'll see you on the next deep dive.
You know, if you look at a piece of paper with a government stamp on it, maybe a property title or a signature from a public official, you just instinctivly trust it.
Right, absolutely.
You don't know the person who signed it. You certainly didn't stand over their shoulder and watch them sign it, but you might hand over your entire life savings based entirely on the weight of that single sheet of paper.
And that's because modern society essentially runs on this invisible infrastructure of paper. It is a shared assumption of trust.
Exactly.
If a certified document says you own the house, well, you own the house. If a state-issued card says you have the credentials to drive a car, you can drive. Without that baseline trust, every single transaction would require some sort of forensic investigation.
Yeah. And when someone tampers with that paper, they aren't just lying to one person on a random Tuesday afternoon. They are actively attacking that invisible infrastructure.
Welcome to the debate.
Glad to be here.
Today, we are examining the legal framework surrounding crimes against public interest in the Revised Penal Code. Specifically, we're focusing on the rules governing the falsification of documents and forgeries.
It is a genuinely fascinating area of jurisprudence, mostly because it forces us to weigh two massive, often competing values. On one hand, we have the survival of our systemic trust. On the other, we have the fundamental rights of the individual accused of breaking that trust.
Right, and that brings us to the core of our discussion today. In prosecuting crimes of falsification, the law establishes a strict prioritization of what it calls public faith.
This framework dictates that actual, measurable damage to a person is immaterial.
Which is a huge detail.
It is. It even creates built-in presumptions of guilt for anyone simply holding a forged document. The question is, do these mechanisms rightfully protect the integrity of society? Or do they dangerously compromise individual constitutional rights, specifically the presumption of innocence?
I'll jump right in here. One perspective, the one I'll be arguing, contends that these rules create dangerous legal shortcuts that threaten fundamental rights.
And I'll be arguing the opposing perspective, that these strict legal mechanisms are absolutely necessary fortresses to protect the lifeblood of trade and government.
So, let's get into it. I look at this legal framework and I just see dangerous shortcuts. I absolutely acknowledge the value of systemic trust, but when we remove the requirement that a crime must actually cause damage, or when we force an accused person to prove they didn't forge a document just because they happen to possess it, we are threatening fundamental human rights. We are essentially punishing people for victimless crimes under the guise of protecting an abstract concept.
And, well, I see it from a completely different vantage point. From my perspective, these strict legal mechanisms aren't shortcuts at all. They are necessary fortresses. Public, official, and commercial documents are the absolute bedrock of our society.
Sure, they're important, but
They're more than important. Without them, commerce stops and government collapses. Let me cite Domagas versus Mullane. The courts have repeatedly held that the principal thing punished in these crimes isn't a specific financial loss, it is the violation of public faith itself, and the destruction of truth as solemnly proclaimed in those documents.
But to presume guilt? That's a massive step.
It's a necessary one, because forgeries are contrived clandestinely. As noted in Cowbang versus People, practical legal presumptions are required. Presuming the possessor of a falsified document is its author is an absolute necessity, not an overreach.
Well, let's look at how that actually plays out in practice. Because the way the law defines the crime of falsifying a public or commercial document is remarkably strict. If you look at Article 172 of the Revised Penal Code, falsification by a private individual does not require any intent to gain.
Right.
It doesn't even require actual damage to a third party. The state essentially argues that the alteration itself is the crime, regardless of who it actually hurts.
It is a strict standard, yes, but it has to be. Let me ground this in a real scenario to explain why the courts have adopted this stance. Take the ruling in Dava versus People.
Oh, the driver's license case.
Exactly. This case involved the falsification of a driver's license. Now, if someone alters a digit on a driver's license, you might ask, who is directly harmed in that immediate moment? It's not like stealing a car where there's a clear victim who lost a tangible asset.
Right, nobody loses money because of a fake ID directly.
Right, perhaps no one is directly injured. But the court held that actual damage is entirely immaterial because a driver's license is a public document. The same logic was applied in Sikian versus People to protect the integrity of commercial documents. The idea of personal gain or intent to injure is simply not required to secure a conviction.
But we really need to pause and ask why we are completely throwing out the traditional requirement of harm. I mean, in almost every other area of criminal law, the state must prove that an action caused or at least intended to cause tangible harm to someone or something.
Let me offer an analogy to explain the underlying logic. Think about how a counterfeit currency system operates.
Okay.
If I print a fake 100 peso bill in my basement and use it to buy a coffee, I might not bankrupt the specific merchant who accepts it. The actual measurable financial damage to that one individual is incredibly minimal.
Sure, it's just a cup of coffee.
Exactly. But if 1 million people print fake bills, the entire economy collapses overnight. The victim isn't just the merchant holding the fake bill. The victim is the currency itself.
I see the parallel you're drawing.
In document falsification, the public faith is the currency. We cannot wait for a specific person to lose their home or their life savings before the state steps in to protect the integrity of official documents.
Okay, I come at it from a different way. I understand the counterfeit money analogy, but a counterfeit bill has no other purpose than to steal value. What happens when someone alters a public document just to fix a clerical error, with zero intent to steal or deceive?
Well, the law is still broken.
Private documents. We see a completely different and frankly much more rational approach. If you falsify a private contract, the law strictly requires actual damage to a third person, or at least the explicit intent to cause such damage.
Because it's private.
Right. This was clearly established in cases like U.S. versus Paraiso. The law naturally recognizes that a lie on a private piece of paper only matters if it actually hurts someone.
But the distinction there is crucial. A private document between two people doesn't carry the state's seal of truth. It doesn't demand the blind trust of the public.
Even so, why should a private individual acting without any malicious intent to injure anyone be caught in the exact same punitive net just because the piece of paper happens to be categorized as public or commercial?
Because the category matters.
But imagine someone altering a date on a public form because they genuinely thought they were correcting a typo, with absolutely no intent to defraud the government. Under the strict reading of this law, they are a criminal. The rigidity of this framework is so deeply problematic that our courts have actually had to retroactively soften it.
You're talking about the Unico case?
Yes, exactly. Look at the ruling in People vs. Unico. The court had to step in and explicitly note that the absence of malice or criminal intent must still be allowed as a defense in the falsification of a public document. Even the judiciary recognizes that blindly punishing every single alteration, regardless of intent, is excessively draconian.
Well, I wouldn't call it draconian. I would call it a necessary deterrent. If the law were lenient, the system would be constantly flooded with innocent mistakes that slowly erode public trust. But I do acknowledge your point about the absence of malice being a defense.
It has to be a defense.
However, that opens up an entirely new set of problems for the justice system. How exactly do you prove malice or the lack of it when forgeries are inherently secretive? People do not forge signatures or alter official land registries in broad daylight in front of an audience.
No, they don't.
And that brings us to the most practical challenge the law faces. Proving malice requires identifying the culprit, which brings us to the presumption of authorship and how we handle the burden of proof.
And this is the exact point where I believe the legal framework crosses from being strict to being genuinely alarming for the average citizen.
I see why you think that. But let me give you a different perspective on why these evidentiary presumptions are the only way the law can function. We just agreed that forgery happens in the dark. It is contrived clandestinely.
Yes, generally.
Because of that reality, demanding direct eyewitness evidence of the physical act of falsification is practically impossible. If the state had to produce a video recording or an eyewitness for every forged signature, the prosecution would never win a single case. The law would be toothless.
So, to compensate for the fact that forgery is hard to prove, the law creates a shortcut that bypasses standard evidence.
It's not a shortcut. It relies on a logical evidentiary presumption. It is a well-established rule, reaffirmed in cases like People versus Manasala and Pechos versus Sandiganbayan, that the possessor of a falsified document is presumed to be the material author of the falsification.
Which is a huge leap.
Let's look at Manansala. The accused had a falsified document in his possession. He made use of it, he took advantage of it, and he profited from it. The court presumed he was the author.
But mere possession.
Let me finish with Pecho. In Pecho, the accused was found holding a forged document and was presumed the forger in the absence of a satisfactory explanation. It's simple cause and effect. If you are the one holding the fake document and benefiting from it, logic dictates you are the one responsible for it, unless you can prove otherwise.
Logic might dictate that. In a casual conversation, sure. But in a court of law, that presumption is incredibly dangerous. You are effectively arguing that possessing a document is an inherently suspicious act that justifies shifting the entire burden of proof onto the defendant.
Only if the document is forged.
But possessing a document is a normal, daily activity for millions of people.
Right. It is normal to possess genuine documents. Holding a forgery is what triggers the presumption.
But the possessor often has absolutely no idea it is a forgery. Let's make this real for the listener. Think about buying real estate. The entire basis of property ownership is holding a certificate of title.
Sure.
Now consider the scenario in People versus Domingo. If someone sells you a piece of land using a brilliantly forged title, and you pay for it and take possession of that title in complete good faith, you are now physically the possessor of a falsified document.
Yes, you are.
Under the framework you are defending, you, the innocent buyer, are presumed to be the master forger who made the fraudulent transfer possible. The state doesn't have to prove you forged it. Instead, they force you to provide a satisfactory explanation to avoid going to prison.
Because you hold the evidence.
But that unlawfully shifts the burden of proof. The state is no longer proving you are guilty. You are being dragged into court and forced to prove you are innocent.
But the courts are reasonable. They do allow for a satisfactory explanation. If you can show you bought it in good faith, like in a normal transaction, the presumption is rebutted. It is a rebuttable presumption, not an absolute decree of guilt.
I'm sorry, but I just don't buy that. Let me tell you why. The moment you force a citizen to rebut a presumption of criminal guilt just because they are holding a piece of paper, you are threatening the very foundation of the Constitution.
That's a strong claim.
It's backed by precedent. I draw strongly on Alonzo versus Intermediate Appellate Court here. The court in Alonzo explicitly stated that this legal presumption of authorship cannot and should not override the constitutional presumption of innocence.
But in practice,
this is especially critical when the evidence that the document is even a forgery is doubtful to begin with. We cannot sacrifice the bedrock constitutional right that you are innocent until proven guilty, just because it makes it easier for the state to secure convictions for clandestine crimes.
I really don't believe it's about making it easier for the state to win cases. It's about making it possible for the state to maintain societal order. If we require impossible standards of direct evidence, our public records will become entirely meaningless.
They won't become meaningless.
They will, because anyone could use a forged document and simply say, "Prove I made it." The law must have teeth to protect the public faith. And speaking of the law's teeth, this connects directly to perhaps the most controversial aspect of this entire framework.
Oh, you mean the threshold of intent?
Yes, and specifically how the law criminalizes negligence through what it calls reckless imprudence.
Which is, without a doubt, the most extreme stretching of the legal concepts we've discussed so far.
Well, let me define what we mean by reckless imprudence for the audience. The law demands such an incredibly high level of vigilance over public and commercial documents that it doesn't just punish people who intentionally lie or forge signatures, it actually punishes falsification committed through sheer carelessness.
Which is terrifying for anyone with a desk job.
We are talking about situations where there is no deliberate malice, no intent to defraud, but rather a profound failure of duty. Look at the case of People versus Bomis. Here we have a director of a hospital. He signed official bills that contained overstated numbers of days of hospitalization.
Wait, he just signed a bill?
Right. The director didn't write those numbers himself. He relied entirely on the reports generated by his personnel. But he didn't check their math, and he didn't have any secondary verification system in place. He just blindly signed the documents.
Right. He was doing his job as an administrator. He was managing a hospital and relying on his staff to do their jobs.
He was blindly affixing his signature to documents that dealt with public trust and public funds, and the court held him criminally liable for falsification through reckless imprudence.
That is incredibly harsh.
Or consider Surep versus Sandigan-Bayan. In this case, an individual made it appear he was a permanent employee on official records, despite lacking the required civil service eligibility. He claimed he did it in good faith, that it was a misunderstanding.
And the court?
The court flat out rejected that defense. When you are handling the public trust, good faith is not an excuse for gross negligence. Punishing reckless imprudence enforces a strictly necessary duty of care. If you put your signature on an official document, the law says you must be absolutely certain of its contents. If you are careless, you are a criminal.
Imagine being a middle manager or an administrator listening to this right now. You probably sign 50, maybe 100 documents a day that your team prepares. Falsification, by its very nature, its historical definition, is a crime of deceit.
Sure, historically.
It requires a deliberate, malicious intent to pervert the truth. When you punish mere negligence, when you put someone in prison for failing to double-check a subordinate's math as a crime against public interest, you fundamentally dilute the meaning of forgery.
But if the result is exactly the same, a false public document entering the system and corrupting the public record, does the specific intent in the person's mind matter as much as their failure of duty?
The damage to the invisible infrastructure is identical.
It matters immensely in criminal law. We are labeling people as criminals, stripping them of their liberty, not just firing them for being bad managers. Negligence is an administrative issue. Deceit is a criminal one.
And the line between them can be blurry when public faith is at stake.
And thankfully, the courts have sometimes recognized how excessively punitive and wildly subjective this net truly is. Let me highlight the case of People v. Mendoza. In this scenario, a chief clerk, acting as a local civil registrar, signed a certified copy of a birth certificate that contained falsities.
Okay, he was charged with falsification through reckless imprudence, exactly like the hospital director in Bahamas. But the court found him not guilty. Why? Because he signed the document in reliance upon his subordinate employee, and the court recognized that he had the right to rely on his staff.
Which the court used to distinguish it from Bahamas, where they determined the hospital director's reliance on his staff was unjustifiable given his specific oversight role.
Exactly. But look at the contradiction that creates. It shows how wildly subjective this framework is. If I'm a hospital director who trusts my staff, I go to jail. If I'm a chief clerk who trusts my staff, I am acquitted. We are casting the net of criminal falsification wide enough to catch everyday administrative negligence.
But again, it depends on the level of required oversight.
Even so, if every manager who signs a document prepared by a subordinate has to live in fear of a criminal falsification charge because of an unseen clerical error, the entire bureaucracy of the country will grind to a halt. Nobody will sign anything. It proves that this framework and its relentless pursuit of absolute systemic perfection becomes excessively punitive against ordinary people simply doing their jobs.
I hear your concerns about the individual burden and the fear it might instill in administrators. But we have to look at this from the macro level. A modern society is an incredibly complex machine. Public, official, and commercial documents are the gears that keep that machine turning.
I don't disagree with that premise.
They allow us to buy homes, drive cars, secure loans, and trust that our government is functioning. To summarize, the rules we've discussed today, the immateriality of actual damage, the presumptions of guilt for those holding forged papers, and yes, even the criminalization of negligence, they might seem harsh when you isolate them to a single individual, but they are necessary prophylactic measures.
Harsh is putting it mildly.
Protecting those documents from tampering is the only way to maintain the integrity of that machine. If we weaken the laws to accommodate every claim of good faith, or if we demand impossible standards of eyewitness evidence to prove forgery, the public faith will slowly erode. And when public faith erodes, the system fails everyone.
Well, to summarize my position, I understand the desire for an unbreakable system, but the pursuit of systemic integrity should never rely on legal shortcuts that bypass fundamental justice. When the law decides that actual damage to a victim is immaterial, it creates a victimless crime. When it presumes a person's guilt from the mere possession of a piece of paper, it unlawfully shifts the burden of proof. And when it conflates everyday administrative negligence with criminal deceit, it crosses a dangerous line. We are risking sacrificing the individual and their hard-won constitutional rights on the altar of a theoretical public faith. We can and we must find ways to protect our institutions without abandoning the presumption of innocence and the core requirement that a criminal must actually intend to commit a crime.
The tension between the practical enforceability of the law and the strict preservation of constitutional rights is profound, and it is clear that it remains an area of deep and continued disagreement. I mean, how much individual leeway can a system tolerate before it breaks down?
It's a vital question. And there is immense value in examining these legal mechanisms from multiple perspectives. It forces us to ask what kind of justice system we truly want to build. Are we prioritizing efficiency or are we prioritizing fairness?
That is the ultimate question.
And there's much more to explore in the source material regarding how these exact same principles apply to other crimes against public interest. We see similar tensions in the laws surrounding perjury or the usurpation of authority, where the state's need for order clashes directly with individual defenses.
Indeed. The balance between protecting the state's invisible infrastructure and protecting the citizens' fundamental rights is a line that moves with every new court decision. It is never truly settled. We leave it to you to consider. The next time you look at that piece of paper with the government stamp,
What are you willing to sacrifice to ensure that stamp tells the truth? Thank you for joining us on The Debate.